From the heartland of America, it's the Bail in the Midwest podcast, hosted by Shane Rolf. Executive producer, David Stuckman.
Hello and welcome to the Bail in the Midwest podcast, where we explore a variety of topics related to bail, pretrial release, and the criminal justice system in the Midwest. My name is Shane Rolf. I'm the Executive Vice President of the Kansas Bail Agents Association, and I've worked in this field for the past 39 years. Now, the state of Washington, especially the Olympic Peninsula, is one of my favorite places in the whole country. My family's vacationed there repeatedly, whale watching excursions on Puget Sound, and hiking through the Hoh rainforest. Driving above the clouds in Olympic National Park is something that everyone should experience. In episode 41, my guest Brenda Dietzman described the experience as spiritually transformative. But other things have transformed in Washington as well. Pike Place Market, one of the big tourist spots in Seattle, is overrun with the homeless, fighting each other and screaming obscenities at the tourists. The food court near the Space Needle carries not the aroma of food, but the funk of the filthy panhandler 3 tables over. Iconic Seattle companies like Amazon and Starbucks are relocating out of Seattle, some to elsewhere in the state and some completely out of the state. Seattle was also the site of the Capitol Hill Autonomous Zone, CHAZ or CHOP or whatever we wanted to call it back in 2020, where city leaders abandoned the 3rd Precinct Police Station and allowed protesters to take over an entire area of the city. A verdict of $30 million was just issued this past month for the family of a murder victim killed in that zone. The city has settled with business owners for millions more for abandoning its duties. Seattle has tried to struggle back and has had some successes. Murders dropped by 36% last year. Seattle PD has hired over 160 new officers and is attempting so-called smart policing by increasing patrols in high crime areas, normal police stuff. But despite these improvements, Seattle is still in the top 5 cities in the country for property crime, with over 5,000 property crimes per 100,000 people, meaning that in any given year, there's a 5% chance that you're going to be the victim of a property crime. And while 5% may not sound like much, the national property crime rate is less than 2%, so it's almost 3 times higher in Seattle. So in the midst of this literal war on crime, the Washington State Supreme Court is being asked to adopt even more soft on crime policies, especially as it relates to bail. My guest today is Courtney Wimer. She's the president of the Washington State Bail Agents Association, and hopefully she can explain to us what's going on in the Evergreen State. Courtney, welcome to the podcast.
Hi, thank you for having me. It's hard to explain such an absurd proposal, but I will do my best.
Well, we'll try and walk through a piece at a time, but let's talk about you just a little bit. Now, you're the president of the association. How long have you been working in bail? What's your bail world backstory here? How did you get involved in all this?
Yeah, so I actually started as a bail enforcement agent back in 2009, and then I became a bail agent back in 2010, so about 16 years ago. And then I've been the president of the State Bail Association for about the last 6 years.
So, as a bail enforcement agent, I mean, some of the questions we always ask people when we get in areas close, like Oregon is a no bail state, right?
Yes.
And so can you even go into Oregon and get people, or do you have to kind of coordinate with local law enforcement there if they go south? Literally south.
We absolutely cannot go into Oregon, but yes, if we have somebody in Oregon, we absolutely do our best to try to coordinate and let the authorities know that they've got somebody in Oregon that needs to get back to Washington, and a lot of times they are cooperative.
Well, we've heard a lot of stories about Portland and how things are going there. I mean, is Portland keeping it enclosed in Portland on that craziness there, or is that starting to expand north and south along in the Pacific Northwest there?
Yeah, I think Portland and Seattle are fairly similar.
Yeah.
The crisis has grown exponentially, I'd say, even in the last 5 to 7 years. You mentioned the CHOP and CHAZ zone was a big disgrace for Seattle. But yeah, Portland and Seattle are on the same track as far as, just crime rate and, once beautiful places that I don't like to even go into at all anymore. And it's sad. I've grown up here in Washington and have a hard time going into Seattle anymore.
Well, that's why my wife really is going to the more rural areas there where there's not so many people around. But Washington's bail laws are really kind of weird to me, looking at this from the perspective of how Kansas does things, and because I'm heavily involved in the Kansas legislative process as it relates to bail in my role as the legislative chair of the association. But I've also seen lots of other states, because when you're looking at making changes to statutory law, you usually will go through and sample other places that have done the same thing. And so I'm looking at Washington, and so prepping for the interview here, it's like, okay, well, what are the statutes? And I'm looking at statutes like, well, that's pretty slim. There's not a whole lot there. And then I get into Supreme Court rules, and it's like Supreme Court rule, CRC 3.2. And it's like, this is an entire chapter of statutory law that's written up as a court rule. It really does strike me as a separation of powers issue going on in Washington. These really seem to be statutes in everything but name. It's really even, and I'm soapboxing here a little bit, so I'll let you talk in here in just a second here. But I was reading one of the cases there, State v. Barton. It's referenced in the bond sheets there that says the courts cannot issue cash-only bonds, which is good. They adopted that, and that was a policy that a lot of states with similar constitutions have said. There's no cash-only bonds. You have to be given the option of using a surety bond. But in that decision I'm reading here, and the court is then arguing about how constitutional its own orders are. It's like, are you both judge, jury, and executioner on this? Shouldn't this have been a statute that then you get to argue to the court, is this statute constitutional? Not is the order that we made, is that constitutional? Are we doing the right thing here or not? It just really struck me as weird. So, but that's been the way that they've done it since, 1973? That's been how they've set up the bail rules?
Yeah, well, and there was a big task force back in 2019 to come up with that Court Rule 3.2, and that involved legislation, members of the Supreme Court, and all of the stakeholders, members from prosecuting attorney's office, public defender's office, the bail industry. So it was really a concerted effort, again, with all of the stakeholders to come up with that Court Rule 3.2 back in 2019. And, it was really, as far as I'm concerned, kind of the gold standard of court rules, because it really, to me, it covers a lot of the basis. It creates fairness, accountability, equity. And you're right, the State v. Barton, Washington is written into the state constitution. You have a right to sufficient surety. So that State v. Barton was, a case in Snohomish County where they made it an extremely high bail amount in cash only and basically removed the right to post with a sufficient surety. But you are not the only one to bring that up to me to argue the separation of powers. That's been one of my arguments during this entire kind of campaign in the last 3 or 4 weeks, is that this should be a legislative issue. This is such a wide sweeping change of our entire pretrial system that you cannot do that behind closed doors with the swipe of a pen. So this should be another legislative issue with all of the stakeholders. There should be studies. The incredible change that this would have and the effect on some of the smaller counties. I've had Superior Court judges call me and say, Courtney, there's no way we could do this. We don't even have the staff to do this. So there are so many absurdities and issues with this proposal, but the separation of powers has definitely been brought up and something we're looking into.
Well, what we're talking about, I guess the issue here is Criminal Rule 3.2 and Criminal Rule of Limited Jurisdictions 3.2. So I'm guessing you have the courts have what we would call a district court here, and then you have a magistrate court and municipal court are the limited jurisdiction courts?
Yeah, so we have a superior court that deals with the felonies, and then we have a district court and municipalities, the municipal courts, yeah. Okay.
So, would the municipal courts be covered under that limited jurisdiction as well, or is that dealing with just the magistrate courts? Because, I know everybody does it a little bit differently. You have, misdemeanors at a state level and misdemeanors at a city level, and then you have felonies, which are always at a state level here. Most of the time, the state level stuff is pretty consistent across the board. The felony level stuff is consistent state to state. It's just when you get into misdemeanors is how we have an entire separate chapter in our statutes to deal with how municipal courts are supposed to handle things, and it doesn't always mimic exactly what the district court is supposed to do. So you could be charged with, you say, possession of marijuana in district court, and you might be looking at a different release process than if you were charged with possession of marijuana in municipal court, even though it's the same charge, but because they're different courts, they're handled a bit differently. Anyway, I'm monologuing a little bit here. So before we get into the details of that, let's talk about, before we get into what of these changes are, let's talk about who's trying to make changes to these rules. Who's pushing this?
Well, the public defender's office in some of the biggest counties, you have Snohomish County, which is like your Everett area, north of Seattle. You have your King County, which is Seattle, and then the Washington Office of Public Defense, which somewhat governs, all of the offices in Washington. But it's mainly those three entities is what's driving this, is your public defender's office.
So strictly public defenders, and maybe some ancillary criminal defense attorneys kind of thrown in there as well. I mean, this is completely on the side of the defense side of things, not the prosecution side of things.
Absolutely. That is correct.
Okay, so let's kind of walk through some of the changes here. And I'll start them off here. One that really stood out to me a lot was the court would, if this change goes into effect, the court would have to make a determination that there was a high likelihood of willful flight, and that's been spread out throughout here quite a bit. It says replacing the current standard of likely risk of non-appearance. In other words, we're looking at your case, given your history, we're thinking, okay, you're probably not going to show up. You have a negative history for this, so we're going to make you post some sort of bond. And replacing that with the Illinois standard of high likelihood of willful flight to avoid prosecution. And then it makes a definition thing of willful flight means intentional conduct with a purpose to thwart the judicial process to avoid prosecution. And this is what really struck me here. Isolated instances of non-appearance in court alone are not evidence of the risk of willful flight. You have to have reoccurrence and patterns of intentional conduct to evade prosecution, and then look at whether any affirmative steps to communicate or remedies any such missed court dates, those all might be considered as factors in assessing future intent to evade prosecution. So essentially, they're giving you a pass for missing court, and they created this huge bar. So tell us more about that. I mean, I before I just explain what I think, why don't you tell me what you think on there?
No, I think you're absolutely correct. It does give you a free pass to miss court. And what it does is it really shifts the burden to the prosecutor to prove, willful flight, to prove that this person intentionally missed court. It's almost impossible to prove. I'm sure you know more about this. Illinois does this. It is almost impossible for a prosecutor to prove an intentional conduct. So essentially, anybody can come in and say, hey, my kid didn't have a ride to school, or, my tire, went flat, or I had an appointment, or whatever it might be. And how is somebody supposed to prove all of those things? And, in my 16 years of posting bail here in Washington, it's already kind of, judges already will say, hey, if you do not have a long warrant history and you have what sounds like a reasonable, reason for missing court, then we're going to give you a chance anyway. So what this really does is it just allows kind of repeat failure to appears to just come up with any sort of excuse without having to prove anything.
Well, so say they've released you, for whatever reason. I mean, and it also creates there's a whole series of things we'll get into later on, Chris, but somehow you end up in custody and then you miss court. Is the court then obligated to issue a warrant, or do they have to give you a pass on that the first time around? How are they handling it if you do ultimately miss court?
Right now, they would issue a warrant for your arrest. Your attorney can argue maybe to try to have you resummoned, or if you communicate with your attorney, the attorney can coordinate with the court and say, hey, this is why somebody missed court. Can we give them another chance? They do have the ability to do that. It's up to a judge's discretion whether they issue a warrant. I think It's kind of common practice to issue a warrant if there is a failure to appear with no reasoning before the court, then they will generally issue a warrant at this point.
Well, because if you had an attorney involved, whether it was retained or court appointed, theoretically, that attorney is going to be there, even if you're not. And if you've had communication with the attorney, you can tell the attorney, oh my God, my tire just went flat, or, whatever, I've got to be at work or I'm going to be fired. I'm going to lose my job. And you're not dealing with a trial. It's like, well, I'm going to jury trial today, so I can't skip work though. It's like, well, priorities, your jury trial might be, I have to, go to the jury trial before work. But a lot of these hearings, as you well know, are hearings where not a whole lot happens. They're just scheduling conferences, they're status conferences. We just want to make sure this case is moving along, doesn't get lost in the weeds. So we call the case and go, hey, you counsel, you prosecutor, let's move this along. Where are we at on this case? But the defendant has to be there for that. And that's the vast majority of failure to appear.
So not to interject, but they actually amended the court rules, I believe back in 2024 already, that allows defendants to waive their appearance at most of those kind of, in between court dates already. And so
felonies?
Yeah. Yep.
Really? Wow.
Yep. They have omnibus hearings. Unless it's a violent crime or the judge can find reasoning that that person needs to be there, it's already assumed that a lot of those little court dates in between, that their presence is waived regardless. So they already changed that to make it, easier for defendants and not interrupt their life as much. So that was already done, by the way.
So in other words, if they fail to appear in these cases, they're trying to excuse failure to appear at actual consequential cases, stages of the hearing, like where there were witnesses, and like where there was going to be testimony, and where everybody else has gotten ready for something to go on, and you just decide that you're not going to show up for court, and then they somehow have to prove that that's willful. Or how do you not prove that that's willful at that stage?
Right.
Again.
Right. Yeah, I completely agree with you, and that's one of the things that I know some of the judges associations that have written comments have pointed out was that. We already amended this to make it easier for defendants. And so this would take it such a step further that it'd be almost impossible to set bail for a failure to appear at this point.
Well, and this kind of gets me into the second thing, and maybe I didn't divide this up the way that everybody else has, but I have it divided up as the second aspect is you must miss court in the same case. So the argument is you have to provide an accused person at least one chance to appear out of custody on their case before the court can impose bail on the amended high likelihood of willful flight to avoid prosecution prong. If there's been a previous finding of willful flight to avoid prosecution on the current charge. So in other words, you could have been historically found to be a willful risk of flight or a risk of willful flight in another case as you had 6 months ago, but you have to miss court in this case now in order to have that finding again. Am I reading that properly?
Yes, you are. It limits judicial discretion to look at previous warrant history and previous criminal history. It is specific to this case. So if somebody has, 37 prior warrants and 43 prior misdemeanor cases, they're not allowed to take that into consideration, according to this court rule.
Well, that's crazy. I mean, if you look at any study that's ever been done, I mean, and we can bicker back and forth with the anti-bail people as to what is more likely to cause a failure to appear. I mean, basically at this point, the anti-bail people have gone, well, failure to appear doesn't matter. Again, we can talk about that maybe some more, but if you look at all this stuff, the one factor, the singular factor, if you had to pick one factor that was going to say whether or not this person is going to miss court, it's going to be, have you missed court before?
Yeah.
And they're proposing to take that completely out of the bond factor equation here.
For the most part, yeah. It's so when we're talking about we're kind of getting into two of the prongs now at this point. Is that
right?
There's the willful flight. If they can prove that person again continuously misses, then I think that they can set bail at that point. But then the other portion is the, and again, I know I'm probably skipping forward, but capping the gross misdemeanor, and warrant amounts for most of those offenses at $200. That's where a judge also can't take into consideration previous warrant history, previous criminal history, regardless of how many times that you missed. That bail would be capped at $200. And then 10% of that. So I know that again, I'm
No, you're fine.
jumping
I have notes
ahead.
on that section as well.
Yes.
There's definitely
When
want to
you
talk
put,
about
when
that.
you put both of those together, what you're talking about is severely limiting a judicial discretion in order to set bail, not only for willful flight, but for previous history. And you're right, the best indicator of failure to appear is past behavior. And if judges aren't allowed to take that into consideration, it's again, you have these judicial officers that are supposed to be making detailed bail decisions. When you take away judicial discretion of a judicial officer that is making a case for an individual defendant based on that individual crime, and they can't take into consideration any of the previous criminal history or warrant history, then how are they supposed to make an individualized determination on that person's bail? It creates like a blanket over judges and what they're allowed to do.
Well, one of the things that we've done legislatively over the years, and we can talk about this more as well, but is we've basically identified some factors that the court must consider. And it seems like prior failures to appear, whether you're on probation or parole, do you live in the state, all these different factors that the court has to take into consideration. If you meet one of those criteria, then you're presumptively not appropriate for a zero bail release. The court can overcome that by making some additional findings, but we're going to start from the position that if you meet these requirements, that you're not going to be eligible for that. It seems like this is turning that on its head, saying, that you are going to be released regardless, unless you then have to meet all these really high bar situations like willful flight.
Well, that's already how it is. So if you look into how Court Rule 3.2 is written currently, they're creating issues that aren't there. According to Court Rule 3.2, the presumption is already released.
Right.
A judge is already supposed to take into your consideration your financial resources. They look into your ties to the community. They already look into all of those, and the presumption is released. So in order for a judge to set bail as is, they have to find under one of the prongs that you're high likelihood to fail to appear, you're a danger to the community, you're going to interfere with the administration of justice, your criminal history. So they already have to prove under one of those prongs in order to set bail. So this whole, hey, somebody's just sitting in jail because they don't have money, well, that's not true. They're sitting in jail because of one of these other prongs that rose above the presumption of release. And so that's why I get frustrated with the whole, it's just all about the money. When no, let's look at why that judge set bail in the first place. Because if it was simply just about money, the presumption is already released.
Well, and also the stuff I've read through on this proposal is they're trying to either limit or eliminate those prongs that you talked about, like the danger to the community prong. They're trying to then change that to mean just violent crimes. So the fact that you've stolen from the same store 16 times in a row, that's not a violent crime. And so you're not a danger to the community. Although one could make an argument, the prosecution can certainly argue, wait a second, repeatedly violating the law is a danger to the community, as opposed to
possession of stolen vehicle is, something I would argue. I'm pretty sure that if somebody goes out with their kids and they need to take them to daycare or they need to, get to work, somebody's going to feel pretty violated. I mean, that seems like a dangerous criminal to me.
Oh, absolutely. I mean, but they're trying to redefine normally judges will look at this and say, danger to the community means you're going to commit another crime. Doesn't necessarily mean you're going to go hurt some particular individual. And this was what we looked at with Illinois. Illinois tried to do the same thing and say, well, you have to be a danger to a specific individual or the community at large, but you have to be a physical danger, not just a danger to public safety or peace or anything else along those lines that most judges would view that as. But then the other prong that you mentioned was to interfere with the administration of justice, interfere with witnesses or administration of justice. It looks like they're trying to make a change to change that language as well, to tighten that up even further, because administration of justice could also be more crimes, failures to appear, those sorts of things. And they're trying to remove that. What are they doing there?
Well, I think I haven't focused as much as that. But I did read that they're trying to make interfering with justice not just, I'd have to look more into that, but I did read that. And I think you're right that they're just trying to tighten that up to.
Well, they're trying to limit it. Basically,
what a judge would consider could be interfering with the administration of justice, like, say, giving a false name or alluding or, things like that. Right now, judges can take into consideration for possible interfering with the administration of justice in the future. And I think that they want to really tighten a lot of that stuff up. Basically, the goal is to just make it a lot more difficult for judges to find any reasoning to set bail.
It looks like they're basically taking away, they're striking the language, will interfere with witnesses or the administration of justice, and changing that to a little bit longer thing is presents a high likelihood of willful flight, or that the person will commit a violent offense, so it has to be a violent offense, or the person will seek to intimidate, tamper, or threaten a witness, victim, or court employee, or tamper with evidence. And that was it. That anything else that would be more of a generic interference with the administration of justice, like picking up a new charge, that's all excised out of there. I think there was even a notation. I've got notes spread all over the place. So I don't know exactly where they were. But they were basically saying, well, the judges use that too liberally, to use administration of justice to mean whatever it wants. And so they're using that to revoke bonds, using that to set higher bonds. And so we're going to have it just mean these three things. And they're very limited in those three things.
Right.
I want to go back to the $200 cap, though. What you mentioned before is that they have to also find, before they can require that $200 bond, for a misdemeanor. And then what is say we're dealing with theft. What's the threshold for theft in Washington? Where does that become change from being a misdemeanor to a felony?
I believe it's $750.
Okay, so $750. So theoretically, you could go into a store, steal $700 worth of stuff. So take $700 worth of stuff from a store, walk out or get caught. And then, and theoretically get arrested. I assume that they're not simply, whether they're issuing summonses or notices to appear or cite and release sort of things. But let's say you get arrested and then the court has to set a bond at you. So essentially, in order to set a bond, they're going to be required to set a bond at $200. Only if they find that you're a high likelihood of willful flight. And even if that's the case, there will be a strong presumption that the court should allow a deposit of a 10% deposit. So basically, it's a $20 fee for getting arrested for stealing $700 worth of stuff. How is that not going to be? Okay, that's a $680 profit for me. I stole $700 worth of stuff, and now I've got $20. Can I use the same $20 I just stole to post that $20?
Well, and the last, I think the last stat that I saw, Washington was third highest in property crime and number one in the nation for police per capita. So not only is that, that's $20. Who's going to care about that? That's a real incentive to return back to court when you just can go out and steal another $730, basically. Mm-hmm. Because here's the thing about the 10% is that we talked to the clerk in King County, which is the biggest county that is already doing this. By the way, already written into Court Rule 3.2, a judge or jurisdiction can use the 10% cash deposit right now. They can already do that if they want to. So King County does this a lot already. And we talked to the clerk, and it's just going in there with an ID and a receipt. Nobody's signing to take responsibility for the other 90%. So when you said, oh, that's another $650 in profit, no, it's really about $730 in profit, because even if you failure to appear, they have no system to collect the other 90%. And And then even if they do and they issue all these warrants on an already understaffed, burdened police department, they're not going to, the police already have a slow response time, but by no fault of their own. So police are already overburdened, overworked. They don't have the staffing. They don't have the funding. They can't really go after warrants already, especially misdemeanor theft warrants. It's tough. And so you take a state that is already so high in property crime, so low in per capita for police, and all this would do is just completely overwhelm the system.
Well, is that not the goal, though? I mean, how do you break the system? I mean, that is your classic version of nonviolent protest, or what do they call when you do a sit-in or something along those lines? You're trying to overwhelm the system. I'm completely blanking on the term, but it was. It'll come to me here in just a second. But basically, if you were protesting at something, the idea was you're going to get arrested. And so we'll get arrested and we'll overwhelm the system, and the system will have to change because the system is overwhelmed. Well, that doesn't necessarily mean you have to have, people volunteering to do that. It's not like you're going, okay, we're going to, gather up 1,000 people and you're going to go steal all this stuff and get arrested. And so now we're going to have to change the theft. You can just sort of change the enforcement. And law enforcement, if they don't have the capacity, and we don't necessarily want them to have the capacity to have, an officer on every single street corner, that's going to be a tough place to live in. That's Soviet style stuff where everybody's a snitch and, pick people. But we also have to rely upon ourselves, that there's going to be consequences when things go wrong. If we're taking that away, then you have a societal breakdown on that. But I'm kind of wondering if that's not the point of some of this stuff. Well, if we can get to where it's impossible to enforce these, if law enforcement can't triage this, then the system will stop and we'll be able to make our cases. We'll be able to defeat the cases because the officer won't show up to testify. I don't know what the mindset is. I do. The mindset on public defenders always used to be, we're going to make sure that people's constitutional rights to a fair trial are preserved. We know we're representing the guilty, but we also going to hold the state to the standard that they need to hold. This seems to be going beyond that. This seems to be going to an activist deal of we want to break the system. And we've seen that in charitable bail as well. Do you get that same impression from these people that are pushing this? Or am I just out with my tinfoil hat on here?
Well, first of all, I want to say, there's a lot of really good public defenders out there. So I definitely don't want to generalize. I know some really good public defenders that really fight the good fight that don't necessarily even believe in all of these changes. But unfortunately, in some of the biggest counties, you switch from a public defender and more to an activist. Mm-hmm. And, I would caution, I guess, that if you want to make such significant changes, how would you feel if this person lived next to you? How would you feel if all of your stuff got stolen, or your friend that owns a corner market couldn't stay in business anymore because of the level of theft? And so it turns into this activism when it's not reality in a lot of ways. It has, at what point, I said this the other day, at what point is public safety not the number one topic of concern? And it has shifted so far from public safety to, defendant and criminal rights that we've lost the voice of the victim in between. And that's where I think I'm, disappointed in some of these public defenders' office is that, they've completely lost the voice of the victim.
Well, absolutely. Well, and they'll take the position that it's not their job to represent the victim. That's the state's job to represent the victim. To represent society and the victim as a whole. Our job is simply to represent that person who's charged and make sure that the state isn't unjustly imprisoning them or unjustly causing a problem for them. And I get that. I really do. And you understand, and it's why we're here. It's why we do what we do, is because you're presumed innocent. That's the reason you have a right to bail, is because there's a presumption of innocence. But that doesn't mean that we can't do anything at all to make sure that you come back to address those charges against you. I never know what the argument is from the public defender standpoint when they go past the to make sure they have a fair trial and that their rights aren't stepped on. It just seems this is going beyond that.
Well, and I think a lot of it's so much of the data is so skewed. And I know I touched on it previously, but it's not like little Johnny that doesn't have a bunch of history sitting in jail because he doesn't have money. No, it's your criminal that has a ton of warrant history, a ton of criminal history. They, then bail gets set. And I would argue is that then shouldn't that person be sitting in jail? How many times do you have to give somebody a chance to either change their behavior, get treatment? There's a lot of programs out there that people can engage in, but how many times do you give this person a chance before you kind of force some of that? And so to want to completely remove that system, I don't think that that's even just to the criminal that's out on the street, that doesn't have housing, that has drug issues. I mean, we've got great community courts. We have great therapeutic courts. At what point, by just continuing to release them and not help them with their struggles by forcing maybe some of this treatment or community courts, which I know you can't force it, but, I strongly suggest it. I would say, again, that it's not just to the criminal to just continue to release them right back on the streets with all the drugs and homelessness either. The criminal justice system can be, kind of an in-between for somebody that, hey, if you go to these community courts and therapeutic courts and you complete those programs, they'll drop your charge and then you get treatment and you get housing. So there's some really good programs here in Washington that if we eliminate and don't let people either get arrested or stay in jail to do some of these programs, then I don't think we're doing them a favor either.
Well, didn't we see that this is up in your neck of the woods? Didn't we see this happen in Oregon and Portland where they decriminalized hard drugs? And well, we still arrest you for possession, but then you were required to go into treatment. But there was no hammer. There was nothing forcing that to occur. And so I think Jason Rance, who also commented on this, did a book, What's Killing America, talked about that, maybe a handful. I mean, they had hundreds of people that were arrested and ordered into treatment. And there was 10 or 15 maybe out of those that actually went, because there was no consequence if they didn't. There was no benefit to them to go through it. There was no consequence if they didn't go through it. The people that argue that Portugal is a great, a great model for how to handle drugs in the system. Well, Portugal still has that hammer as well. You'll go to treatment or else you'll go to jail. They always leave off that or else go to jail part. But if you don't have that, I mean, did Oregon ever roll that back, or are they still dealing with the decriminalization things, heroin and methamphetamine and such?
I believe that they rolled quite a bit of it back, but I'm not certain on that.
Right.
I'm going to bring up a small story here where, we had a gal. Yeah. So we, different company that I'm really close with, they had a gal out on bail. She missed court. The bail enforcement agents went and found her all the way across the state, hours away, with help from the family. The family wanted her found as well. Mm-hmm. Mom, literally basically led them to her. They brought her back here into Pierce County. They've been searching for months for this gal. And the next day, the judge reinstated the bond without permission and released her. And that mom had worked so hard to locate her. And the bonding company did their job. They brought her back to jail. And the mom had been trying to locate her for so long and was excited to locate her and get her back into custody. So therefore, she can come up with a treatment facility. She can, she wrote a 5-page letter that I have actually, because she was so angry that without any information, she had already missed court a bunch of times, and the court just released her again. Unlawfully reinstated a bond without permission. So, it's things like that have happened to where we have had families get really frustrated that their loved one has been out on the street for months on end, or sometimes years on end, And they finally get arrested thinking, gosh, the court system is going to help. They're going to get them some treatment. Or they come to us and say, you guys, please don't post their bail. This is what we need to do. And I'm like, absolutely. And under this proposal, they would just be out. So it creates a revolving door. And when I talk about victims, I'm not always talking about victims of crimes. Sometimes defendants are victims. Sometimes their families are victims. And so when a public defender can't see that all they care about is, their person not sitting in jail, and maybe can't say, hey, maybe they should be. Maybe let's talk to these community courts. Let's try to get them in there. Let's talk to the families. Let's do what's actually right society-wise for this person, as opposed to just nobody should be sitting in jail. And that's where I said that it disappoints me.
Well, and we see that all the time in drug cases, especially where the family wants them to remain in custody because they're going to dry out. They won't even, despite what we hear on, all these different shows about, drugs in prison, everything else, generally there's not going to be anything in your county jail that's going to be an issue like that. And so I think even another podcaster, Ken Good, has described, the county jail as poor man's rehab. If we don't have the insurance to go pay $30,000 to go through a month of rehab, well, we can get the same results here, at least the dry out phase of it for 30 days sitting in the local county jail. Now, the local county jail doesn't necessarily want to pay for that, but that's another issue. But either way, that person's being removed from the street. They're being removed from the drugs. They're not doing, people that are using drugs are a major driver of crime because they can't hold a job. If you're strung out on heroin or fentanyl or whatever, it's not like you're going to work in your heavy equipment. You better not be anyway. And so how do you pay for the drugs that you're using? So if you can get that person removed out.
If you put together elements of this proposal, the capping the most gross misdemeanors and warrants at $200. And then you take the presumption of 10% and make it the $20. Imagine, I'm sorry, but sex traffickers, cartel, drug dealers, that's all they have is money. So if any young girl can walk in with an ID and post, bail for basically anybody they want, you're removing all of the accountability. And imagine if you could walk in with $100 that you just went and stole the week before and post bail for 5 of your buddies. I mean, that's going to create such a disproportionate system. We had an issue about a month ago, and this is a true story here. We had an issue about a month ago where a gentleman was in King County, our largest county here in Washington, for promoting prostitution, sex trafficking. Set the bail at $200,000. A couple of young girls walk in with an ID and $20,000 cash. And he had a felony gun charge from another county. He gets transported to that county. And the attorney says, well, Your Honor, he just posted $200,000 in King County. And she said, well, that's a pretty significant amount. Okay, we'll only set it at 25 here.
Right.
Well, I happened to see that judge the next day and explain what really happened, that there's no other liability. And she was furious. It was extremely misleading to her. It's extremely misleading to the public, not to mention the fact that who are these young girls walking in with an ID on a sex trafficking case? Are victims going to be coerced or threatened? Because now you don't have the bail bondsman that's going, hey, who are you?
Right.
What's your job? What's your employment? What's addresses? How do you know this person? Because we actually get to know these people before, and you're obviously very aware, we get to know our clients before we post bail. We get to know their friends, their family. This takes away all of that and just allows anybody with an ID. And I think that that's extremely scary as well. And I know there's victim advocates that have spoke out against this and commented on this. There's a lot of, you can look at it from so many different angles on the changes, and there's a really scary instance in almost every angle you look at.
Well, all of these more lenient release processes, they always end up in breakdown in the criminal justice system where they are. If the police, and this is nothing against police, but if a police officer comes across somebody and they know that all it's going to take is, I'm going to take this guy to jail. I'm going to spend 4 hours booking him in and getting all the paperwork done on this, and he's going to pay $20 and walk back out the door. I've got other things to do. I'm waiting for this call that's down the road. I'm just going to pass on this. And then when that happens, people don't call the police when a crime occurs, or when they do call the police and somebody gets right back out again. And suddenly that person that you thought you were going to be protected from has paid $20 and they're right back on the block. And, we've got snitches get stitches, being stared at you down the road. Then you have people not making those complaints. And we saw the same thing happen in Philadelphia. I know that some of the counter arguments to this pointed out that Philadelphia study where the city of Philadelphia ended up being owed over $1 billion in unpaid forfeitures over that, and that they end up completely writing off. But what they found was the dismissal rate in cases went up because witnesses didn't show up, because even if they weren't if the charge wasn't being made about intimidation of witness, they were being intimidated by that person being right back out there with no consequence. So, I mean, it really is breaking the system when you just decide, well, we're not going to have anybody in custody, so we'll let everybody go again, on the mantle of the presumption of innocence. It's frustrating.
Yeah, I agree.
And
another portion of that prong is that it completely eliminates the language that would allow a judge to deny bail on capital offenses.
Right. I was going to get to next.
Yeah.
Go ahead.
Well, it's just we had an instance here where a couple of young women were gunned down outside of a bar, and the guy fled to Mexico. They put him on the FBI's most wanted list. It was the quickest capture on FBI most wanted list. And he gets back here and they set bail at $5 million. Well, from what I'm told, it was his brother that turned him in and got the $1 million reward. So you're saying that brother can just come with the $500,000 and post bail for his brother with an ID and just take him back? Because now, because you wouldn't be able to deny that bail on capital offenses. That's, to me, that is just a prime. It's such an egregious story. And what a slap in the face to victims that, we're talking about the worst of the worst, premeditated murder.
Right.
And the prosecutor right now can put together a packet and tell this judge, what an extreme danger this person is to the community. And the judge has the right to make that decision. They would eliminate that. And that is, again, we're talking the worst of the worst. So why on earth, even as a citizen, would you not want somebody's bail denied in that faction? We're not talking about the, yes, murder too. All that stuff is terrible. Things happen. Premeditated murder. That's a completely different category of people.
Does Washington still have the death penalty?
No, they abolished the death penalty quite a while ago.
But they have made the change to where they can deny bail to someone who's looking at life imprisonment, like a first degree murder thing, correct?
Nope. Well, they do now.
Currently, right?
Currently, correct. The proposal is trying to remove that.
Right. And so then I think this is the whole putting the part in there where we're removing the ability of the court to deny bail in capital cases or life imprisonment. I think that actually lets you know what it is they're trying to accomplish here. It's not, poor people are sitting in jail because they don't have any money. You're talking about letting someone, go who 15 years ago would have been subject to the death penalty. And that's not poor people sitting in jail. That is one of the most heinous crimes that you can charge in here. And you're advocating that person needs to be able to be bonded out with 10% to the court, or what have you. And they're looking at going away for the rest of their life. That was always the argument I had for why is it okay to deny bail in capital cases? One, because the Constitution says so, but two, because there's no amount of money that's going to make you come back and say, okay, I'm ready here for you to execute me. That's nonsensical. So there's no point to granting those people bail because there's absolutely nothing that will get them back to court. But to sit there and say, well, we just want to get these poor people out of jail, but we also want to get accused murderers out of jail. That seems like a bridge too far.
Right.
No.
Right. And that's why there's so much about this proposal is absolutely absurd. I go through the comments every morning, and I noticed a comment on there this morning that caught my attention because I knew who it was. And it was the mother of a defendant that is sitting here in Pierce County for multiple charges of depictions of minors engaged in sexual activity. I mean, some of the worst child crimes that I, in my 16 years, have ever read. It was all over the news. The judge, the prosecutor, all said this is some of the worst, most egregious crimes we have ever seen. I mean, trapdoors in the house, trazodone to want to get sex slaves, kid for a sex slave, going to other states to scout kids. I mean, they found all of this. This is one of the most egregious cases I have ever seen. And the judge appropriately set a really high bail. And the mother of this defendant put in a comment under this proposal that said it is unfair, that she agrees with the proposal because it is unfair that her son is sitting in jail and you shouldn't have to choose money over bringing the loved one home. That's one of the comments in favor of changing this court rule. One of the most egregious child sex cases that has ever been seen in this state. I don't even know what else I have to say about that. It's shocking.
Right. Well, you're going to get that. There's, you can, her son's in jail. So, you can, if you can discount it for that, it's like, oh, this is terrible. My son should be out. That's not the best person to be making a policy type decision, because there's an emotional investment. You're looking at this from, if you make law based on outlier situations like that, or just totally upon empathy, you're going to end up with problems. But you've been looking at this commentary that comes in. So who is actually, I know with the defense attorneys and maybe some mothers of crime victims are for this, but who is against this? I've seen some interviews on television from somebody, and who's posted commentary that, beyond just random people on there, who are institutional people that are opposed to this?
Yeah, we've had elected prosecutors speak out against this. The District and Municipal Court Judges Association has spoke out against it or submitted a comment against it.
That seems like a big one.
Well, the Superior Court Judges Association put in a comment against it. About 30-ish different legislators all signed a letter against it, saying this should be a legislative issue. I spoke to several different people that I know. The Sheriff's Association is looking into this. Almost anybody that is related to the criminal justice system that is not the public defender's office is putting in comments wanting to object to this proposal.
Well, hopefully the court will listen to that. That is the problem also with it being a court rule with this commentary period. There's not a lot of transparency there. You don't have, I guess judges are elected there, sort of, but they're not responsive to the people in any great thing like legislators would be. Your senators and your representatives, they have to go back into their communities, and they were voted by 3,000 to 5,000 people in their district to send them up to the state legislature, and they have to go back and explain to those people, this is why I did this. Or their people can come in and say, this is bad. You also have 150 different points of view that are coming there saying, well, what about this? How do we change this? There might be some things in here that are good that maybe I haven't found any, but maybe there's somebody that finds that they're good. And so then you go and say, well, let's keep this, but let's get rid of this. And so that's what you have when you have the parliamentary process. The legislative process is people, lots of different people have input, and ultimately you end up with something that everyone can agree on, mostly in the end product. When you have something like this, just the judicial branch itself creating its own statutes to run its own behavior, you don't have that. You don't have that transparency, and there's no answering to the people on this, other than if you're going to vote out some Supreme Court justice, 4 years or 6 years down the road. Anyway, I'm really big on this separation of powers issue. Anyway,
Yeah. Well, and that's why we have, this is the third time that they've proposed to amend this court rule. And so far, the Supreme Court did not pick it up.
Right.
And so I wasn't overly concerned because I thought, gosh, this proposal is absurd. And then I had a couple of Superior Court judges call me and say, no, we just got back from a judge's meeting and we think that they're actually going to push this through. And, you're correct. It is behind closed doors. People pay attention to legislative issues. It's all over the news.
Right.
People pay attention. There's elections. Most people have no idea what the Supreme Court does, the makeup of the Supreme Court, their authority. And so to have something that would completely change the face of the entire pretrial system done behind closed doors, essentially with the swipe of a pen, I know I couldn't let that stand, which is why we have, reached out and there's been so much media and we've requested comment. The Supreme Court has said that this is the most comments they've ever received on a topic. The Supreme Court does have the option to hold a public hearing on it, whether they will or not, whether it's requested of them or not. I'm not sure. But this is by far, again, the most comments that the Supreme Court has ever received on a topic because it's not being behind closed doors. We are getting this out there and the media is doing their job and, voicing both sides of it. Absolutely. The bottom line is the public needs to know that this is going on. Public safety has been such a concern here in Washington, your property crimes. So to have something like this go on behind closed doors is outright outrageous, honestly.
Well, it's a single branch of government and the least accountable to the people branch of government. I mean, if this was a statute, it would have to pass through the legislature, the governor, and both houses of the legislature. The governor would then have to sign it into law or have to be overridden if the governor vetoed it. And then after it passed those two parts of the government, then it would have to withhold constitutional scrutiny from the courts.
Right.
In this instance, the courts are just saying, well, we're just going to do this. We're going to create our own statutes, and forget that legislative executive branch stuff. So we don't need them for this. That seems like a perversion of our system of government on how these things get enacted because no one's accountable on this. I mean, again, however you select your judges, they're still the least accountable branch of government that's out there for good reason. But the good reason is that they're limited in what they can do. They can determine constitutionality. If they're the ones that are least accountable and they're out there creating functional statutes, that's a problem, I think.
Yeah, absolutely. Yeah. And there's been quite a few people that have brought that up. And, we've already looked into the fact of, hey, if they adopt these proposals, what is our next step forward? Right. And it's extremely limited when the next step forward would be addressing this with the exact court that jumped and proposed changes. And so you're right. It absolutely should not be done. To me, it is a huge overreach of the court's authority, and should just simply be a legislative issue. I mean, these proposed changes eliminates a function of the system without any sort of proposed change to replace it. So, I mean, you talk about the bail bond system that has been around for, centuries essentially, and is proven true. We have all the rules, we have the regulations. It's functioning. It's functioning well. So to eliminate that industry without any sort of proposed idea on how courts would even, I mean, you can't, there's no way. We've had several court clerks say, there's no way that we could even track this. Right. I mean, they track failure to appears for bonds right now, but how would they try to forfeit this money? How would they try to get this return, the 10%, to somebody? What if they don't come pick it up? Then they have to send it to the IRS for unclaims. It creates a nightmare for the court system. And there's nothing in the proposal that accounts for that.
Well, exactly. I mean, because it's being made up out of whole cloth by people who just want to get people out of jail. You have to let people go. Period. The end. All right.
Yeah.
So I've taken up a lot of your time. I know we had some technical difficulties that managed to delay us a little bit. So you're not appointment, but so let me read the deal here. It says the comment period for the proposed rule changes runs through April 30th. So coming up really quick. Comments can be submitted to the clerk of the Washington State Supreme Court. You can email your comments to supreme@courts.wa.gov, and we will put this at the end of the podcast as well, so people can pull that up from there also. How many people would you like to respond from out of state? Because I mean, you're going to see a lot more people probably watch this from out of state than in state. Does it help to have out of state commentary on that? Well,
listen, I think anybody that has, and I know I welcome if anybody has any ideas and wants to reach out to me personally, I welcome that. There's a lot more people that are more intelligent in this issue that are in the room than I am. So I welcome.
You seem to have this down pretty good.
Well, I appreciate that, but I welcome any suggestions, ideas. And I think anybody that has knowledge of how this has worked in other states, I think that the court needs to hear that. So I would love all of those comments with any information that people can provide. The more information that the court has, I think the more hard pressed they would be to deny this proposal.
Well, I know Missouri, and it's just me kind of trying here. I know Missouri did a rule like 303.03, 303. Anyway, I forget exactly what it was, but basically it was a directive to the court saying these are the things you had to consider when setting bonds, and that sort of fit more into the administrative rule. This is our determination of how to handle this sort of thing. But this is a far cry. I'm not aware. And again, there's other people that see more states than I do. I'm not aware of any time that the courts have just basically usurped both the legislative and executive branch. But again, that's the way it's been done in Washington since the early 70s. You created this out of whole cloth. It should have probably been written in statute. And then the courts could tweak that if they found some violation. Legislatures could change one thing here or there, as opposed to just a wholesale change of the whole system.
Yeah. Well, and I think, I talked to I'd say somebody that is running for the Supreme Court that pointed out that this is not, there's been multiple instances with the Supreme Court, I'd say in the last 5 or 10 years, that have been questioned on their authority and should have been a legislative issue. It feels like the Supreme Court in Washington has kind of been running rampant and needs to be, the makeup of the Supreme Court is interesting right now. We had a couple of Supreme Court justices just retire, very level-headed justices. So 2 were just appointed, I believe. And we have 5 Supreme Court seats up for election in November. So that could be a pro or a con, but the public definitely needs to pay attention to what they're doing, because I think that this is now being pointed out, the scope of the things they can do and the change that they are trying to affect. So, yeah, the public needs to pay attention because, again, 5 of these justices are up for election in November.
Looking at it politically, I mean, just cynically, you can see things going both ways. This would be a good time for them not to do anything at all, because we don't want to throw out an election issue. Said, hey, we just decided to let all the criminals go. Now vote for me again. Or you could go, if you have a very progressive base that you're trying to appeal to that agrees with that. Look at what I did. I just made bail more fair. But I know that, like in Iowa, multiple years ago, when gay marriage was the hot topic there, the Iowa Supreme Court found a constitutional right to gay marriage in their constitution, and every single one of the justices that were up for retention, because it was retention elections, not elections in the traditional sense, but every single one that was up for retention that cycle immediately thereafter was not retained. And so they basically cleared out 3 of the Iowa Supreme Court justices after that because of that ruling. So they can be a little hinky on how the response is going to be on that, just because if it is some big wholesale thing that's a hot button issue, a lot of times the courts like to stay away from that because they like to, we're not legislating. It's like, although this looks a lot like legislation.
Well, and we'll see. The court can choose to adopt the entire proposal. Right. They can choose to adopt a portion of the proposal, or they can choose to not pick it up at all. And so I believe, yes, the comment period ends April 30th. They have 90 days to make a decision. Doesn't mean they have to take that full 90 days, but they have up to 90 days. So we'll see. But I know that we're going to keep fighting. Just because the comment period ends April 30th, listen, they're still going to be sitting at home thinking about this. So as far as I'm concerned, I'm going to keep the pressure on until there's any sort of decision, and possibly past that if need be.
Well, at least we're with you in sympathy, if nothing else. Yeah, I mean, I hope you get it. I mean, one, I don't like the way this is done, but the entire ideas are bad. I mean, we've seen it play out every place else across the country. You know, that any time that this has been done, you've seen crime go up, you've seen failures appear increase, you've seen participation in the judicial system just by victims. I'm not calling the police. Nothing's going to happen. If you go softer on this, crime gets worse, the whole situation gets worse. So hopefully you'll be successful on this.
I couldn't agree more, and I appreciate the attention.
Thank you very much for taking the time to talk to us today, Courtney. I really appreciate it. I really hope you can pull this off. We would like to thank our guest, Courtney Wimer, for taking the time to talk to us today. These proposed changes in Washington state are terrible for both bail and for the citizens of Washington. Hopefully, the Supreme Court will not adopt such a wholesale change to the pretrial release process in Washington. It really does strike me that this is a legislative function to establish these ground rules, not a judicial function. Both the prosecutors and the Washington judges don't want this to occur. Hopefully, the Supreme Court will not adopt this. But please join us on the next episode of the Bail in the Midwest podcast, where we'll continue to bring you conversations and critical information from people involved in the criminal justice system.
To submit comment on Washington State's proposed court rule changes, please email supreme@courts.wa.gov. Join us again next time for the Bail in the Midwest podcast, hosted by Shane Rolf and executive produced by David Stuckman.